Good afternoon. My name is Guillermo Casino, the chairperson designate of the New York City Loft Board. I welcome you to our May 15, 2025 public meeting. We're having technical difficulties, so we won't have a video recording for this meeting. But we will have the audio recording. Section 282 of the New York State Multiple Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the legalization of interim multiple dwelling units from commercial and manufacturing spaces to legal residential units that comply with the minimum standards of safety and fire protection in Article 7B of the New York State Multiple Dwelling Law.
Chairperson,
To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of legalization, and prosecutes parties who violate the lawful law and the law board's rules. We'll first turn to a vote on the minutes from the April 17, 2025 public meeting. Are there any corrections or comments to the minutes?
I have one question. On page 3, it mentions the executive director aiming for publication date of May 1st for the target date of May 1st for the rule that we adopted. Did we make it?
Yes.
Good. So it's in effect as of the end of this month.
Stealing my thunder from the report, yes.
I'm sorry about that. Thank you.
Sure. Thank you. Is there a motion to accept the minutes? Thank you, Mr. Singletary. Is there a second?
Second.
Thank you, Ms. Piskel. Thank you. Ms. Rivera, can you please pull the board members?
Ms. Briscoe-Bernstein,
Yes.
Mr. Bauer,
Yes.
Ms. Biscoe,
Yes.
Mr. Delaney,
Yes.
Mr. Secretary,
Yes.
Ms. Rajon,
Yes.
Ms. Rosen,
Yes.
Chairperson Patino,
Yes.
8 in favor, 1 absent.
Thank you. Next, we'll have a staff report from our executive director.
Good afternoon. I am very pleased to report that the notice of adoption for a 5 egress rule was published on May 1st. The rule will be effective on May 31st. IMD owners will receive a copy of the rule and the new required notice for the lobby in the mail. Copies of these materials are being done right now, and we anticipate a mailing very soon. The rule and the notice are on our website. Second is personnel. We have identified a candidate for the vacant paralegal position. The candidate is going through the DOP vetting process now. We are scheduling interviews for the attorney level 3 position and the deputy position. The annual building registration. We are also preparing materials for the building registration renewals, which are due on July 1st. We're in the process of revising the instruction sheets. Owners, please be advised, you'll be required to submit payment of the registration fees online in the DOB Now system. The required registration forms can be sent to us via email, mail, and personal delivery. We also remind owners to file the fire egress certification that will be due on July 1st. The certification will be included in the registration materials. Next, regarding legalization and narrative statement conferences, we've had 12 since the April board meeting.
Is that you speaking?
Our usual planning day for the June meeting is a national holiday. The June board meeting will be held on June 26th at 2 p.m. here at 22 Reed Street. Any questions?
Thank you. We'll now turn to the case agenda. There's one case on the summary calendar. It's 394-400 South 2nd Street in Brooklyn, docket number TA0251. Are there any comments on this case? Is there a motion to accept this case?
So
Thank you, Mr. Singletary. Is there a second?
yes.
Thank you, Mr. Bowers. Ms. Rivera, can you please pull the board members?
Ms. Briscoe-Bernstein,
Yes.
Mr. Bauer,
Yes.
Ms. Biscoe,
Yes.
Mr. Delaney,
Yes.
Mr. Secretary,
Yes.
Ms. Rajon,
Yes.
Ms. Rosen,
Yes.
Chairperson Patino,
Yes.
8 in favor, 1 absent.
Thank you. We'll now turn to a vote on the cases on the master calendar. First case is 255 McKibben Street in Brooklyn, docket numbers PO0138, TA0271, PO20260, and TA0325. Also note that we'll be making a correction to the proposed order on the first page in the second paragraph. That starts off on August 15, 2022. We're making a correction to the second date that shows up in that paragraph, which currently reads August 2, 2012. It should read August 2, 2022. So you want to present this case?
Thank you, Chairperson Patina. Good afternoon. This is a case of the matter of Yen. The tenants will here file applications for protected occupancy status and rent overcharge. In its opposition, owner argued that the unit was not subject to rent regulation 225 purported sales of right pursuant to MDL 28612. Judge Clark in the report found 4 out of the 5 transactions were not sales pursuant to MDL 28612. The proposed order accepts the recommendation regarding the four of the sales. The pivotal issue in this case is whether the 2022 sale transaction between the owner and the tenant constitute the sale of rights, Article 7C rights. To demonstrate that a valid sale of right occurred, there must be proof of an intentional relinquishment of a known right and a valid consideration. In 2019, when tenants signed a lease and sales of rights agreement for the unit, they were informed by the owner's representative of their Loft law rights and were further directed to contact the Loft board for more information. The tenants know that the unit is an IND. The preponderance of evidence in this record supports a finding that there was an intentional relinquishment of unknown rights. Tenants contacted owner for a rent adjustment because of financial concerns in 2020. They received a 200 check from owner, which they cashed, but they dispute that they did not sign a second sale of rights agreement. Owner testified that he agreed to a monthly rent adjustment of $1,000 and an additional $200 in exchange for tenants selling of their Article 7C rights. To support his claim, owner provided a copy of the signed sales of rights agreement and a copy of the check of $200. Casper Yen, one of the tenants, acknowledged receipt of the check. The check has his signature. Part of the evidence presented by tenants to prove their claim was a servitor's recording of the 2020 meeting during which owner agreed to reduce their rent from $5,000 to $4,000. In the recording, tenants were heard talking about initialing a document, and owner is also heard requesting confirmation that the documents were signed. There is nothing in the tenant's recording which supports that the allegation that they refused to sign the sale of rights. The weight of the evidence supports tenant's narrative, owner's narrative. The proposed order finds that the unit was subject to rent regulation between June 2019, when tenant took possession of the unit, through May 2020, before they sold their Article 7C rights, and the tenants were protected occupants of the unit. The proposed order further found that after May 12, 2020, tenants were no longer protected occupants, and the unit is no longer subject to rent regulation based on the 2020 sale of rights. Any questions? Thank you.
Thank you. Are there any comments on this case? Mr. Brady?
I'm going to vote against this case. It seems that this owner is a serial buyer of 28612 rights, and in this case, he bought them, or attempted to buy them, or claimed he bought them from 3 prior sets of tenants. We find those are not valid. He tried to buy the rights when he was renting this unit to the applicants, and they signed the agreement because they wanted the unit. And now they came to him in the early days of the pandemic seeking a rent reduction, and once again, like the deli putting a napkin in the bag, when you buy a breakfast, an egg on a roll, there was that sale of rights. And I don't believe that a $1,000 a month rent concession and a $200 check adds up to a purchase of sale of rights. Plus, he let them stay in the unit. All he wanted was to, buy rights. And I don't think he did. I don't think this is a valid sale of rights. I'm going to vote no. I think the board should reverse this position and find the tenants to be protected occupants of the unit.
Any additional comments?
Well, I tend to agree. I must say I've been thinking about this. I've read it a couple of 3 times. And it's just really, I get to the point where I agree here and then disagree there, and agree here, disagree there. And I thought maybe I would abstain from this right now, but I think I'm going to probably vote no.
If I may, what impresses me about this case is that the owner did tell the tenants in 2019, you should go to the Loft board to inquire about your rights. And I'm sure the Loft board would have said, if you want to know about your rights, go to an attorney to be better informed. We're not going to advise you. And I don't think the tenants trusted what the landlord was saying either, and that they surreptitiously taped the owner throughout the meetings with the owner. So they did have a basic distrust, which ought to have led them to find out more. And I think that there was a rent reduction for 6 months of $1,000 plus a $200 check. $6,200 is sufficient. $10 certainly is not. And the landlord eventually, on the 5th try, learned how to properly buy a tenant's rights. So, but I don't think there's anything nefarious about the owner's ignorance in those first 4 attempts. So that's my piece.
There are motions to accept these cases? Mr. President McKee, is there a second? Thank you, Ms. Russell. Mr. Rivera, can you please poll the board members?
Ms. Risco-Nisby,
Yes.
Mr. Bauer,
No.
Ms. Dinkelpin,
Yes.
Mr. Delaney,
No.
Mr. Singletary,
Yes.
Ms. Rajan,
Yes.
Ms. Roach,
No.
Chairperson Patino,
Yes.
5 in favor, 2 against, 1 absent.
No.
3
Three.
against,
No,
sorry.
3 against.
5 in favor, 3 against, 1 absent.
Thank you. The next 2 cases on the master calendar are removal cases. First one is 64 Washington Avenue in Brooklyn, docket numbers LE0735 and RG0230. And 139 South 8th Street in Brooklyn, docket numbers LE0760 and RG0227. Are there any comments on these cases?
Can we separate them possibly?
Yes, because of Is there a motion to accept the first case, 64 Washington Avenue, Brooklyn, docket number LE0735 and RG0230?
Yes.
Thank you, Mr. Rosenberg. Is there a second? Thank you, Mr. Rajan. Mr. Rivera, can you please poll the board members?
Ms. Risco-Nisby,
Yes.
Mr. Bauer,
Yes.
Ms. Dinkelpin,
Yes.
Mr. Delaney,
Yes.
Ms. Singletary,
Yes.
Ms. Rajan,
Yes.
Ms. Rosen,
Yes.
Chairperson Patino,
Yes.
8 in favor, 1 absent.
Thank you. The next case is 139 South 8th Street in Brooklyn, docket numbers LE0760 and RG0227. Is there a motion to accept this case? Thank you, Mr. Rajan. Is there a second?
Second.
Thank you, Mr. Singletary. Mr. Rivera, can you please poll the board members?
Ms. Risco-Nisby,
Yes.
Mr. Bauer,
Yes.
Ms. Dinkelpin,
Yes.
Mr. Delaney,
Yes.
Mr. Singletary,
Yes.
Ms. Verdon?
Yes.
Ms. Wilson?
Yes.
Chairperson Patino?
Yes.
8 in favor, 1 absent.
Thank you. Any final comments before we close up?
If I may, for just a moment, on item number 3, I note that owner waived its rights to a rent adjustment based upon code compliance costs. And I just want to note at this time that that application form is impossible and does not comport with reality. And I, for one, would very much like to particularly redraft the application form and take a look at the regulations. And I know that the Loft Board is understaffed at the present time, but when the Loft Board staffs up, I hope to get some help in undertaking this project.
Thank you. Additional comments?
Well, I was wondering if it was possible to get a copy of the current form, and is the current form based upon, is it DHCR that would have the same form for for a capital improvement project?
Yes, I can provide the board with a copy. I'll email it to you. And I don't know about the insurance form. I don't know what their application is like for MCI or those.
I don't either, I've never seen it, I just know there is one, so I guess.
I could bring that, the DHCR form.
That would be great to be able to sort of understand the genesis of the form at least. Right?
Yeah.
Thank you.
Thank you. So we'll conclude our May 15, 2025 public meeting. Our next public meeting will be on June 26, 2025. Thank you.